Okay, good afternoon, ladies and gentlemen. Welcome to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. Plea and motion to revoke probation docket. Today is Thursday, April 22nd, 2021 at approximately 2:15 p.m. The cases I have set today on pleas, State of Texas versus Lydia Herrera Esparza, cause 635-922, represented by Christopher Castro. State of Texas versus Julian Rodarte, cause 635-259, represented by Charles Mice. And let's see, I guess our motion to revoke probation, cause 640-444, State of Texas versus Antonio Pena, represented by Mr. Abel Dominguez. State of Texas versus Caroline Flores, cause 633-156, represented by David Christian. And State of Texas versus Margaret de la Cruz, cause 347-834, represented by Ms. Kramer. Have we heard from Ms. Cruz, de la Cruz?
No, Your Honor. Ms. Kramer is on standby. She didn't know if maybe Ms. de la Cruz would show up, but she has not.
Okay, all good. Let's get the MTRs out of the way, starting with State of Texas versus Antonio Pena, cause 640-444, with represented by Mr. Abel Dominguez. Mr. Dominguez, are you with us today?
Yes, I am, Your Honor.
Okay. And cause 640-444, Mr. Pena, I'm looking at actually two documents. The first entitled, Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both your signature and your attorney's signature on it. Is this your signature on this document, sir? Mr. Pena, your microphone is turned off. I'm sorry. There you go.
Yes, sir.
Thank you. And Mr. Dominguez, as attorney for Mr. Pena, is this your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which states is a revocation of the defendant's community supervision, and the defendant has the right of appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document, Mr. Pena?
Yes, sir.
And Mr. Dominguez, as attorney for Mr. Pena, is this your signature on this document?
Yes, it is, Your Honor.
Thank you. Representing the state, who we got today, Nick or Alexis? We got Alexis, Ms. Alexis O'Connor. Representing the Bexar County CSCD is Ms. Susan Gross, where I will swear at this time. Ms. Gross, please raise your right hand. You swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, to help you God?
Yes, sir, I do.
Thank you. My understanding, Mr. Dominguez, is this is an uncontested motion to revoke. Is that correct?
That is correct, Your Honor.
Okay. This is actually a first amended motion to revoke community supervision. And on the motion to revoke community supervision, how does Mr. Pena plead?
Yes.
Antonio, do you plead true or not true to the
Sure.
motion?
Sure.
True? Court
Yes,
of
sir.
true, and you certainly may explain it at the appropriate time. Ms. Gross, would you please advise the court and the parties of the status of Mr. Pena's probation in cause 640-444?
Judge, Mr. Pena never showed up to sign his conditions of probation after he was released from court on the day he was granted. So he has not made any payments. He didn't have any classes or any community service. He hasn't been drug tested. Therefore, we are recommending that his probation be revoked.
Does Mr. Pena have any prior offenses?
Yes, he does, Your Honor.
Yes.
He has quite a few.
Okay. Ms. Gross, do you have access to a list of those?
Yes, I am getting that right now for you. Okay, Judge, he has an assault bodily injury, assault of a public servant with bodily injury, assault bodily injury, assault bodily injury, assault bodily injury, driving while intoxicated with an open container, possession of a controlled substance, penalty group 1, less than 1 gram, assault, family, choking, strangulation, assault, bodily injury, married, criminal mischief, 100 to 750, criminal trespass, private property. This case, which is criminal trespass, private property, burglary of a habitation, and evading arrest or detention, or both awaiting hearing.
Okay, and this offense is a class A, I'm guessing, criminal trespass on private property. Would that be true or not?
I believe it is a Class B, Your Honor. I looked it up on the record and it's a Class B.
Not a habitation, so it may well be a B. State, would you say it's a B?
I can verify really quick, Judge.
Yes, Your Honor, it is a Class B.
And Ms. Gross, what was the original sentence underlying for apparently a year?
His underlying was 6 months, Your Honor.
And what was the original fine?
He did not have a fine. The only thing that he was assessed was court costs and attorney fees.
All right, so we had a $0 fine. Would that be accurate?
Yes.
Defense, your request?
Your Honor, we would ask that if the court were to revoke him, if this matter be judgment satisfied, my client has been incarcerated for 9 months, 9 months actual days. So we would ask that this be judgment satisfied. And we would also ask, though I'll be honest, I haven't spoken with the DA about it, that the new case, the evading arrest, be taken care of as well with this matter.
Okay, so he has not had any confinement for this particular case, but or if he has, it's gone along with some other cases. Is that correct?
No, I believe
Your Honor?
he was picked up for the MTR.
Your Honor, on this actual case, he has the 296 days.
On this case, he has 290 days.
Yes.
I'll do it. State, do I have your permission to TIC the other pending case, which is an evading arrest case, cause number 643769? In this case, if I give him a maximum sentence of 6 months, credit for time served, it's going to be judgment satisfied.
Yes, Judge.
Is that okay with you, defense?
Yes, it is, Your Honor.
Mr. Pena, on clause 640444, the court accepts your plea of true to all conditions on the motion to revoke probation with an explanation. I grant the state's motion to revoke your probation. I sentence you to 180 days in the Bexar County Jail, a $0 fine plus court costs, credit for time served, time and money to run concurrent. Taking into consideration clause 643769, which is granted and it shall be dismissed. And judgment satisfied. Anything further from the state or the defense on Mr. Pena?
No, Your Honor.
Good luck, Mr. Pena.
Thank you.
Thank you, Mr. Dominguez. Y'all are excused.
Thank you, Your Honor.
Let me do some writing here real quick. Okay. Next case I've got clause 633156 out of Texas versus Caroline Flores, represented by attorney David Christian. Once again, Ms. Flores, I have 2 documents I need you to advise me whether you have signed or not. The first one is titled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Mr. Christian, as attorney for Ms. Flores, is this your signature on this document?
It is, Judge.
We're dealing with a motion to revoke community supervision. So the next document I'm looking at is a trial court certification of defendant's right of appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction, unquote. Is this your signature on this document, Ms. Flores?
Yes, sir.
And Mr. Christian, as attorney for Ms. Flores, is this your signature on this document, sir?
Yes, sir, it is.
All right. And Mr. Christian, my understanding is this is uncontested motion to revoke community supervision. Would that be accurate?
That's correct. It'll be true with the explanation, your Judge.
So on the motion to revoke community supervision, how does the defendant plead?
True.
All right. Ms. Gross, would you please advise the court on the parties of the status of Ms. Flores' probation at this time?
Yes, Your Honor. Ms. Flores has done well as far as reporting goes. We last saw her on March 30th of 2021. She's paid $1,544 towards her fees. She has a balance of $60 and she is paid ahead at this time. She's completed 38 and a half of her 60 hours of community service. She's had 9 negative drug tests. Early on in her probation, she failed to show for drug testing on one occasion and failed to submit on another. She's completed DWI education, victim impact panel, stress class, CATSNP class, and she is currently on Smart Start Mobile, where she is testing 6 times per day. As noted on the motion to revoke, she had 19 skips. Since the motion has been filed, from the time period of March 16th to April 16th, she has had 53 additional skips. This is her second violation report. Her first motion to revoke. Her prior arrests include obstruction of highway, intoxication, assault, bodily injury, harassment of a public servant, and this case. Due to the excessive misses on the Smart Start mobile device, Your Honor, the officer is recommending that she be placed on a Scram device in lieu of a Smart Start mobile.
And how many total skips over what period of time are we dealing with on the Smart Start mobile device?
As alleged in the motion, from January 19th to March 22nd, she had skipped 19 tests. From March 16th to April 16th, she missed 53 tests, 53 tests.
Mr. Christian, what's going on with our testing?
Well, Judge, thank you for asking. And real quick, Ms. Gross, I think on this one, she had done all the community service hours. Remember, this is the one where she made the donation. I just want to be at.
The only real issue in this case is skipping Smart Start mobile blows, which would
Yes, Judge.
which would indicate to the uneducated that she's drinking during those time frames and trying to hide it by not playing in the machine. So
Yeah, Judge. Yeah, let me address that. Judge, I'm really happy to report that I do not think it's that situation. I do not think it's an alcohol situation at all. I've had extensive talks with her about this. She'll be happy to tell you it is not drinking related. Judge, if I may, the majority of the tests that are skipped happen on the first test, the 5 to 7 test. One of the issues with this young lady is that she has a sleep disorder problem. And very often she doesn't go to bed till about 3 a.m. and then sleeps through her alarm. She also is recently living by herself, which is also part of the problem. Judge, let me just tell you 2 seconds about the skips also. Whenever she does skip, she tests on the next time, and they've all been negative. She also has had a couple of little issues with the malfunctioning device. The primary reason for the skips, though, is her own fault, obviously, her own lack of responsibility on this, but it's not drinking. I've been doing this a long time in front of you, and me and you know that a lot of times it is drinking. I'm here to tell you that it's not a drinking issue. I believe that she has been sober this entire time. I believe that she has not had any drugs in her system this entire time. We've had extensive talks that she believes the DWI education was very valuable, that the CATSNP was very valuable. Judge, I'm also happy to report that at the time that she pled, the time of the offense, she did not have her family in her life as she should have. When I reference her family, I'm speaking of her father and mother. Her father is now in my office right now with her. They have a firm grasp on it. They've come up with a plan to set alarms. They've come up with a plan to call her. They've come up with a plan to not let it be charged. Ultimately, it's her responsibility, as you know more than anybody, but she now has a support system that knows. She tried to keep it from them, Judge, and that was part of the problem because she was embarrassed. So I would ask you, if you do decide to give her another chance on Mobile Smart Start, if you can just move that one window to later at night, even if it's from 12 to 2 in the morning, I believe we will not have this issue again. Just to let you know, Judge, when she was arrested and remanded without bond. She had to go spend the night in jail. She was there for probably over 35 hours. She might correct me because it was probably longer. And it was a very traumatic experience. She is gainfully employed. She lost her job at the beginning of COVID, but immediately found another one. Like I said, her dad is in my office. He has a firm understanding of what's going on. I don't believe it's a drinking issue. She's, when we talked to the mobile Smart Start people, they told her that if it was a drinking issue, then they could see a positive test in the very next window, because she tests for some reason in the next window. And so I don't have all the access that Susan does, and I hope Susan doesn't jump all over me here if I've said something wrong. But I will tell you that there's not been any positives on the drugs or on the mobile Smart Start. I've never seen anything like it, Judge. I think if you give her one more chance and we just move that one window to later, I think that we're not going to have any problems with her at all. And I'll stop right there because I'm sure you're getting tired of hearing from me.
Judge, if I may.
Sure, go ahead.
In reviewing her report over the last 30 days, she is not consistently skipping that initial test between 5 and 7 a.m. Her tests are all over the board. She misses 5 to 7. She misses the 10 a.m. test. She tests late. She misses the 5 o'clock test. She misses the 12 o'clock test. She's all over the board. So, you know, Mr. Christensen, I'm sorry, but her saying that she needs that initial blow moved, it's not the only test she's missing. She's missing all the tests all throughout the day. And it's not a consistent issue. And secondly, she's already been blessed because her tests are supposed to be scattered equally over 24 hours. And her officer was gracious enough to give her a sleep period of 6 hours.
Yeah, and I'm sorry, I did not lead to say that they're only in that window. It's just when we try to narrow it down and I try to get into the what's going on, that seems to be the main issue. But I'm not trying to say that that's the only test missed. I am trying to say that when she's misses or she's late, there's never been a positive one. And so, Judge, I'll leave it at that. We'd ask that you just change that one window because I got dad in her life. I think the 30 hours of jail really woke her up. Variety of things like that. She's up to date on everything. And so I think that's the one issue. So Your Honor, that would be my request.
Did you represent, David, did you represent Ms. Flores when she entered a plea on this case originally?
No, sir, I did not. She did not tell her family about it, and she showed up on her first setting and did plea. And they have found out subsequently, and they found out loud and clear when she got arrested, when she showed up at probation.
Hey, do you have access to any aggravating factors off the original arrest? Here's my my issue. I think she had a prior obstruction, correct? But this case, that may have been the aggravating factor. But, you know, she's on basically 2 years probation for a Class A, and they wouldn't even waive the greater than 1.5. So they were mad at her at the time, it would appear. But I'm wondering if there was a major accident or something involved back then. Do we know?
I'm looking it up right now.
Ms. Flores, was there an accident at the time you were arrested on this case?
Yeah, so I actually was in a car accident, and that's when the cops were called. There was nobody injured, just
all right.
me.
Thank you for that question. Alexa, you don't need to look at it. I've got it figured out. All right. I have two options, and I'm going to ask the state which one they want to recommend. My first option is put Ms. Flores in jail for a year, and that will fix it. My second option is to put her on a scram bracelet, which costs plus or minus $350 a month. That will ensure if she drinks, we find out about it. I'm willing to make a deal with the devil and say that if she does 90 days on the scram bracelet successfully, I'll give her another shot at the Smart Start Mobile. But she's got, what, a year and a half left on probation, Susan?
Yes, sir. She has until July 9th of 2022.
State, those are my two options. Which one do you prefer?
I'm going to recommend scram, Judge.
Defense, is that something that y'all can do?
Judge, we can do it, and I appreciate you doing a 90-day just to show that she's not going to I think it's the right message all the way around. So I think that's, yes, we can do that.
Ms. Flores, before I finish, I want you to close your eyes and take yourself back to sitting in jail for 30 hours and think how fun that was. And then multiply that times 12 months, because that's what's facing you if there are any more problems. You've been a model probationer right up to the point where you don't blow into my machine. That's kind of our only issue in this case, realistically. So if she can show me a clean 90 days on this scram bracelet, that's a bracelet that goes on your leg and detects alcohol if you drink it 24 hours a day. The real downside is it costs you guys a lot of money to do that. But on the upside is you're going to get to sleep. You don't have to wake up in the middle of the night and blow on the machine, all that stuff. So is that something the defense is willing to accept, David?
Yes, sir, Judge.
Ms. Flores, that's something you're willing to accept? All right, fair enough. And where are you working with now, Ms. Flores?
I work from home.
I'm doing what?
IT sales.
Okay. In cause 633156, the court accepts Ms. Flores' plea of true to all conditions on the motion to revoke probation with an explanation. I deny the state's motion to revoke her probation order, continued on probation with all prior requirements with no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Do I already have your attention, or would that 30 days be something that would help? No, we're good? All right. Altering amending conditions, adding a scram bracelet within 5 days. If there's a problem with scheduling and Scram says we can't get to her for 10 days or something, David, just call me and let me know what's going on. We'll work that out. She states, Smart Start Mobile, you got to keep blowing in your Smart Start Mobile. Apparently you haven't been doing that right up to this point until we put the Scram bracelet on you. Then you can turn in the Smart Start Mobile device and save that $95 a month or whatever that is. Susan, is there anything else we need to do on this case other than that?
No, Your Honor. Ms. Flores, your officer will be sending you alternate amended conditions, hopefully sometime this afternoon, as well as your scram order. Once you get that, go get your scram device. You have 5 days. Judge, can we give her 6 days since tomorrow's a holiday?
We'll give her 10 days. How's that?
All right.
Because I'm convinced that Mr. Christian is right and I have Ms. Flores' attention.
All right. So you'll have 10 days in which to get that. Once you get strapped with scram, call your probation officer, let her know. She'll verify it. Then she'll notify the court and the judge will sign a Smart Start mobile device, which she will then fax to the company. And then you'll be able to go in and turn in that device. You need to keep blowing at your scheduled blows with no skips until you are strapped with scram. Okay. You have any questions? All right. I'm going to do this paperwork and send it to your officer here in about 5 minutes. So if you haven't heard from her by 3 o'clock, why don't you go ahead and give your officer a call? Okay.
And before we cease operations, David, you've got Ms. Flores' father with you in your office. Is that correct?
I do. He would like to
get an opinion on whether he agrees that that's a fair result from the facts that I've got, or if he's got any other concerns he wants to bring before the court at this time.
Thank you for asking, Judge. This is him right here. This is Mr. Flores.
Hey, Mr. Flores, for the record, would you state your name, sir?
Roger Flores.
And Ms. Flores, you're the father of our defendant, Caroline Flores, in clause 633156. Is that correct?
Yes, I am, Judge.
And you've been a witness to the entire hearing today and heard everything that was said by all the parties?
I have, sir.
Do you agree with the court's decision, or do you have any other concerns that you want to bring up at this time?
No, sir, I agree with it. I think you were very fair, and I do appreciate that.
All right. Thank you very much, sir.
Thank you, sir.
To you and to Ms. Flores and Ms. Christian, thanks for your assistance. Y'all are all dismissed.
Thank you.
Thank you, sir.
Yes.
Okay. Have we heard from Ms. De La Cruz yet? Pat, your microphone is off.
No, Your Honor, we have not heard anything from her. That's probably going to have to be an FTA, Your Honor.
I need to issue a warrant for her. All right. So we got now
The please.
pleas on Lydia Herrera Esparza. And
if you're going to issue FTA, may I be excused?
yes, you may. Thank you, Ms. Rose.
Y'all have a good day.
I've got clause number 635922, State of Texas versus Lydia Herrera Esparza, and clause 635259, State of Texas versus Julian Rodarte. So, representing Mr. Rodarte is Mr. Mice. Are you ready to go forward at this time, Mr. Mice?
Yes, Your Honor.
Thank you very much. And representing Ms. Herrera Esparza is Mr. Castro. Are you ready to go forward at this time, sir?
Yes, Your Honor.
Let's see. This is clause 635259, State of Texas versus Julian Rodarte, and clause 635922, State of Texas versus Lydia Herrera Esparza. Once again, Mr. Rodarte represented by Mr. Charles Mice, and Ms. Herrera Esparza represented by Mr. Christopher Castro. At this time, Mr. Rodarte and Ms. Herrera Esparza, I'm looking at document entitled Defendant's Consent to Plea by Video Conference, which purports to have your signature and your attorney's signature on it. Mr. Rodarte, is this your signature on this document, sir?
Yes, sir.
Thank you very much. And Mr. Mice, as attorney for Mr. Rodarte, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. Ms. Herrera Esparza, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Castro, as attorney for Ms. Herrera Esparza, is this your signature also on this document?
Yes, Your Honor.
Thank you. Mr. Rodarte and Ms. Herrera Esparza, the next document I'm looking at is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Rodarte, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Herrera Esparza, is this your signature on this document also, ma'am?
Yes, Your Honor.
By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? If you had any questions about what was on these documents, those questions were answered to your satisfaction by your attorneys, so that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Rodarte?
Yes, sir.
Thank you. And is that correct, Ms. Herrera Esparza?
Yes, sir.
As attorney for Mr. Rodarte, Mr. Mice, have you had enough time to go over the case with him? And in your opinion, is he mentally competent?
Yes, Your Honor, he is.
Same question for Mr. Castro as attorney for Ms. Herrera Esparza.
Yes, Your Honor.
Mr. Rodarte, are you a United States citizen, sir?
Yes, sir.
Thank you. Same question for Ms. Herrera Esparza. Ma'am, are you a United States citizen?
I'm a permanent resident, sir.
Ms. Herrera Esparza,
Yes, sir.
not a citizen of the United States of America, a plea of guilty or nolo contendere for the offense charged may result in your deportation, your exclusion from admission to this country, or the denial of naturalization under federal law. Mrs. Esparza Herrera, have you discussed with your attorney and been made aware of the mentioned consequences? And are you still knowingly wanting to enter a plea to this offense?
Yes, sir.
Okay. As attorney for Ms. Herrera Esparza, Mr. Castro, have you had the ability to discuss with her the possible problems she may encounter with regard to her immigration status if she enters a plea to this crime?
Yes, Your Honor.
And after you discussed that with her, did she indicate to you she wanted to go forward at this time with a plea bargain with the state?
She didn't indicate otherwise, Your Honor. I will ask on the record if she would like to confer with an immigration attorney prior to proceeding.
Ms. Herrera, basically at this point in time, I'm just trying to confirm that your attorney's had a chance to talk to you about the possible immigration issues that might arise if you go on probation or resolve this today with a plea. Do you have any more questions for him? You want to go into a breakout room and chat with him about this, or are you okay?
Yes, please, if that's possible.
Yeah, absolutely. Why don't you send Mr. Castro and Ms. Herrera to a breakout room, please?
Okay, I'm gonna send you all to breakout room 1. And there you go. You should be able to join. There you go. Okay.
Okay, back on 635-259 to the Texas versus Julian Rodarte. Mr. Mice, as attorney for Mr. Rodarte, has the state fully complied with discovery for you on this case?
They have, Your Honor.
Thank you. Mr. Rodarte, to the offense of discharging a firearm in a community with a municipal population greater than 100,000 people, how do you plead, sir? And defense counsel, you can enter into, is it a no contest or a guilty plea?
Judge, it should be a no contest, Your Honor.
Is there an agreement for Mr. Rodarte?
Yes, Judge, it's $6.
Yes, sir.
$200 fine plus court costs. 40 hours of community service, an APSE course, restitution, if any, to Brittany Rodarte, and a motion to forfeit the weapon.
What kind of weapon is it? On your report of this, what kind of weapon? Like this, Rodarte, what kind of weapon is it? Handgun, I'm guessing? Mr. Rodarte, can you hear me, sir? Mr. Rodarte? Mr. Rodarte, your microphone's turned off, accidentally.
Can you hear Mr.
Hello?
Rodarte? There you go.
Mr. Rodarte, what kind of gun was it?
It was a AR.
AR type rifle? Okay. Mr. Mice, in lieu of destroying this weapon, would you be willing to accept it as additional attorney's fees with the understanding it's not going to be returned to Mr. Rodarte, his family, or his friends?
Yes, Your Honor.
Is that okay with you, Mr. Rodarte? We lost your microphone again, Mr. Rodarte.
He's out of the.
Hello?
Is that okay with you, sir, as far as your gun goes?
Can you repeat it, please? My internet's really acting up.
And award it to your attorney as additional attorney's fees in lieu of destroying it. Is that okay with you?
Destroying it?
Instead of destroying it, I'm going to give it to your attorney to use because it's probably a valuable weapon. I don't know. As long as it's not stolen or some other issue comes up on it. You're not going to be able to get the weapon back is where I'm coming from.
Hello?
We hear you.
I can't. Can you repeat that, please?
Sure. I have options on this gun. I can either destroy it or I can award it to your attorney as additional attorney's fees and let him have it. It's not going to be returned to you. Is that okay if I do that?
Yes, sir.
Thank you. And State, you were so kind and gave me a document with all this sentences and stuff, and I've misplaced it. So hang on. Make sure I get this right. Okay. Mr. Rodarte, in clause 635259, the court accepts your plea of no contest to the offense of discharging a firearm in a municipal area with a population greater than 100,000 people. I find you guilty. Is that correct, State?
Yes, Judge.
Right. It'll be 6 months in the Bexar County Jail, probated for 1 year. Is that correct?
Correct.
$300 fine plus court costs, 40 hours community service, APSE stress management course, restitution, if any, to whom? I'm sorry.
Brittany Rodarte.
Brittany Rodarte.
Mm-hmm.
Was somebody injured with this weapon, or why would there be restitution? Is my question.
There was damage to her vehicle, Judge.
From the state perspective, what happened in this case?
According to the police report, it was alleged that somebody might have been stealing the vehicle, so the defendant fired the weapon and ended up hitting Brittany Rodarte's Jeep.
Was she in it at the time?
I'm sorry, what, Judge?
Was she in her vehicle at the time?
No.
Defense, do you agree, plus or minus, that's kind of the story?
Yes, Your Honor.
Okay. Mr. Rodarte, clause 635259. Court accepts your plea of no contest to the offense of discharging a firearm in a city with a municipal population greater than 100,000 people. I find you guilty. I said 6 months in the Bexar County Jail, probated for 1 year, a $300 fine plus court costs, 40 hours community service, APSE, stress management course, order you to pay restitution, if any, to Brittany Rodarte, and the weapon is awarded, or state's motion to destroy the weapon is denied, and the weapon is awarded to defense counsel as additional attorney's fees with the understanding it's not to be returned to the defendant, his family, or his friend. Is that your understanding of the agreement, State?
Correct, Judge.
Is that your understanding of the agreement, defense?
Yes, Your Honor.
Mr. Rodarte, we gonna have any more problems or are we good? Can you hear me?
Hello?
We gonna have any more problems or are we good?
No, we're not gonna have any more problems. I'm sorry.
Good answer, sir. Thank you.
My internet is messing up really bad.
What is probation gonna
Okay,
do?
Mr. Rodarte, probation will be
Yes,
contacting
ma'am.
you in 48 hours. If you do not hear from them within 48 hours, and I would say closer to Tuesday, because tomorrow's a holiday, you need to call them. Do you have a pencil or paper so that I can give you the phone number? Are you ready? Okay, you ready?
Your microphone is muted, Mr. Rodarte.
I think he's having trouble, he said, with his,
Yeah.
I'm sorry.
okay. The
Yes,
phone
ma'am, I'm ready.
number, okay, the phone number is 210-335
Okay.
7200, and you ask for intake, and it'll be your responsibility. And I would say Tuesday, if they haven't contacted you, late Tuesday, to call. If you do not contact them, there may be a warrant for your arrest. Okay? Did you get the number?
Yes, ma'am.
Okay. All righty then. That's it.
Good luck, Mr. Rodarte. Thank you, Mr. Castro.
Thank
Well,
you.
very excuse, Your Honor.
Nice, thank you.
Thank
Yes.
you, Your Honor.
Now we're talking to Mr. Castro. Back on the record on 635-922, State of Texas versus Lydia Herrera Esparza.
And
Defense,
they're still in a breakout room.
are they still in the breakout room?
Yeah, you want me to go in?
Oh, no. Yeah, okay. I thought they were back.
You want me to go off YouTube for right now?